This is Constitutional Rights in Black and White.
In 1994, Christy Brancala was a student at Virginia Polytechnic Institute. Within a month, she reported to the school that she had been raped by 2 male students. The school held a hearing and found that one of the male students was indeed guilty of sexual assault, but the school later reversed that decision and found one of the students guilty of only using abusive language and permitted the male student to return to school. Ms. Brancala became depressed, stopped going to class, and eventually dropped out. Brancala sued the students. She did so under a provision of the Federal Violence Against Women Act, which permitted her to sue any person who commits a crime of violence motivated by gender. Her case went to the Supreme Court, where she argued that Congress had the power under the Constitution to permit her lawsuit. No, said the Supreme Court, it didn't. Every law enacted by Congress must be based on one or more of its powers enumerated in the Constitution. Congress exceeded those powers. Congress did not have the power to pass this legislation in the first place, so you do not have the ability to bring a lawsuit. But wait, said Ms. Brancala, Congress has enormous authority to regulate the country, commerce, public and private institutions, and the people who live here. And violence against women is an epidemic in this country. It's Congress's job to intervene. Not like this, said the Supreme Court. The Constitution has a Commerce Clause that gives Congress power to regulate commerce among the several states. And it's true that the Commerce Clause gives Congress a lot of power to regulate those activities having a substantial relation to interstate commerce, i.e., those activities that substantially affect interstate commerce. But violence against women isn't commerce. Gender-motivated crimes of violence are not economic activity, so Congress cannot use the Commerce Clause to regulate them. Well, said Ms. Brancala, the Commerce Clause isn't Congress's only power here. It also passed the Violence Against Women Act under Section 5 of the 14th Amendment. And Section 5 states that Congress may enforce, by appropriate legislation, the constitutional guarantee that no state shall deprive any person of life, liberty, or property without due process of law, nor deny any person equal protection of the laws. Violence against women deprives us of our life, liberty, and property all the time. And when the government doesn't do anything about gender-based violence, it's denying women equal protection of the laws, in part because not doing anything about gender-based violence allows gender-based violence to continue. So Congress was within its power to pass this remedial legislation. No, said the Supreme Court, Section 5 only permits Congress to enforce these rights against state actors, not private individuals. Regulating that kind of private conduct is the job of the states, not the federal government. Wow, said Ms. Brancala, so you're saying that Congress can't intervene to stop gender-based violence or race discrimination or a whole bunch of other social problems if those problems are driven by private actors? Basically, yes, said the Supreme Court. United States versus Morrison was a slap in the face to Congress and an enormous setback for civil rights, including women's rights and safety. It was also a big power grab by the Supreme Court, an assertion that it has the final word over Congress's power to remedy discrimination. It suggests that the court will be very restrictive whenever Congress tries to remedy all kinds of structural and social discrimination. Okay, so let's read the case. United States versus Morrison is a case about federalism, judicial supremacy, and gender discrimination. In passing the Violence Against Women Act, Congress tried to combat gender-based violence by creating a civil legal remedy that allowed victims of gender-based violence to sue perpetrators of gender-based violence in federal court. The Supreme Court decided that Congress lacks the power to do so. The decision limited Congress's ability to enact civil rights legislation and to address other important issues that conceitedly have nationwide consequences. The court's opinion also rested on a muscular notion of judicial supremacy, the idea that Congress must defer to the Supreme Court's views about the Constitution. Christy Brancala was a student at Virginia Polytechnic Institute when, she alleges, she was raped by 2 male students. She reported the rape to the school, but the school's process ultimately failed to protect her. The male students she identified as her attackers were permitted to remain in school, and she dropped out. She sued the 2 students under the civil provision of the Violence Against Women Act, VAWA, which permitted her to sue any person who commits a crime of violence motivated by gender. The Supreme Court took the case to decide whether Congress had the power to pass the provision in the first place. Here's what the Supreme Court said. The court starts with what is known as the enumeration principle, which refers to the idea that Congress can only exercise powers enumerated or contained in the Constitution. One of the most expansive powers is Congress's power to regulate commerce among the several states, the so-called Commerce Clause power. This power has been used by Congress to prohibit race discrimination in public accommodations, criminalize loan sharking, regulate controlled substances, and establish crop quotas for farmers. Congress can regulate those activities, the court has explained, because they substantially affect interstate commerce. But the court began to cut back on Congress's commerce powers in the 1990s. The case that began to do so is United States versus Lopez. Lopez struck down the Gun-Free School Zones Act, which made it a crime to possess a firearm in a school zone. The court in Morrison relies heavily on the reasoning in Lopez. First, the court notes, gun possession in schools is not commerce or an economic enterprise. That made it too remote from interstate commerce. This is really important to the court's decision, and it comes back up several times. The court also notes two other aspects of the reasoning in Lopez. One is that the statute did not contain a jurisdictional hook, limiting the statute to cases that have some connection to interstate commerce, such as where a gun had traveled in interstate commerce. The same is true here. Additionally, in Lopez, the court struck down the gun statute because Congress had not made legislative findings regarding the effect on interstate commerce from gun possession in schools. By contrast, when it passed VAWA, Congress made extensive findings about the serious impact that gender-motivated violence has on victims and their families. Justice Souter's dissent highlights some of Congress's more specific findings. One is that 3 out of 4 American women will be victims of violent crimes. Another is that violence is the leading cause of injuries among women ages 15 to 44. Still another is that violence against women is a cause of homelessness. And still another is that violent crime against women costs $3 billion a year. Why wasn't this good enough for the Supreme Court? Because gender-based violence is, according to the court, non-economic activity. And the court adopts a strong presumption against aggregating the effects of non-economic activity. That is, if the activity was economic, we would ask, does all gender-based violence together substantially affect interstate commerce? But because it's not economic, we don't. That is, the court doesn't care that gender-based violence has a substantial effect on the nation's economy. Why adopt a line distinguishing non-economic from economic activity? This rule seems like it's crafted based on a slippery slope argument. If Congress can regulate the conduct here, that reasoning would allow Congress to regulate any crime as long as the nationwide aggregated impact of that crime has substantial effect on employment, production, transit, or consumption. The court worries that this reasoning could apply equally as well to family law and other areas of traditional state regulation. And the court claims that federalism does not permit such a result. You might ask yourself what kind of federalism the court is thinking about. That is, what requires there to be a division of authority between the states and the federal government over certain subject matters. Notice that the court does not give up its ability to aggregate non-economic activity altogether. We need not adopt a categorical rule against aggregating the effects of any non-economic activity in order to decide these cases. But the court decides not to aggregate here. We reject the argument that Congress may regulate non-economic, violent criminal conduct based solely on that conduct's aggregate effect on interstate commerce. It's worth pausing over the implications of the court's theory. What if pollution from driving cars or having chimneys in houses affected the economy? Justice Breyer in dissent raises this question. Would the court say Congress is powerless to regulate because that is non-economic? Or what if, and this might seem far-fetched, there were a pandemic sweeping the country and the uncontrolled spread of the disease affected the economy? Could Congress require vaccination? This possibility actually came up at an oral argument after Morrison. And here's what the lawyer had to say in response to a question from Justice Breyer.
I'm just picking on something I'd like to go to. If it turned out there was some terrible epidemic sweeping the United States, and we couldn't say that more than 40 or 50%, I can make the number as high as I want, But you'd say the federal government doesn't have the power to get people inoculated, to require them to be inoculated, because that's just statistical.
Well, in all candor, I think Morrison must have decided that issue, right? Because people who commit violence...
Is your answer to that yes or no?
Oh, I'm sorry. My answer is no, they couldn't do it because...
They could not do it. They cannot require people, even if this disease is sweeping the country, to be inoculated. The federal government has no power, and if there's terror... okay, fine.
The court's test requires courts to divide up the world into economic versus non-economic activity, and it's not always obvious how to draw that line. As Justice Breyer notes in dissent, in Perez, the Supreme Court upheld a federal statute that prohibited extortion, making threats, to collect on a debt, and upheld the prosecution of a defendant who threatened to harm his victim and his family. But in Morrison, the court distinguished Perez, treating violence against women as non-economic. You might ask yourself, why is extortion, making threats to collect on a debt, economic activity, but violence against women isn't? Or why is drug possession or growing crops economic activity, but violence against women isn't? As Justice Souter and Justice Breyer note in their dissents, the court has previously allowed Congress to regulate non-commercial activity, like when Congress set quotas for domestic agricultural production. The court recognized that agricultural production may not be regarded as commerce, but said Congress could regulate it anyways, since it still has a substantial economic effect on the country. In addition to its Commerce Clause holding, the court also rejects Congress's power to enact this provision under Section 5 of the 14th Amendment. This is a significant portion of the decision. Section 5 states that Congress may enforce by appropriate legislation the constitutional guarantee that no state shall deprive any person of life, liberty, or property without due process of law, nor deny any person equal protection of the laws. This provision and related ones have provided the basis for the infrastructure of American civil rights laws, including anti-discrimination laws that regulate voting. But in Morrison, the court held that Section 5 only allows Congress to regulate state actors, since the 14th Amendment's substantive guarantees apply only to states. That doesn't really acknowledge how VAWA's civil remedy against private actors responds to the action or inaction of states, like Virginia Tech's failure to discipline the students found guilty of rape. In effect, the court holds that Congress should have allowed people to go after state officials but not private individuals. But that's a funny kind of federalism. Why is it better for federalism that Congress authorizes people to sue state officials rather than private actors? Here, too, the court's decision rests on a formalistic line-drawing exercise. It's true the civil remedy is against private actors, but there's state action all around gender-based violence against women. As the court's opinion notes, one of the reasons why Congress enacted VAWA is because state officials weren't prosecuting cases of gender-based crime, based on sex stereotypes and victim blaming, among other things. And that state inaction is part of the problem, which the facts of this case illustrate. This is also the point Justice Breyer raises in dissent. Here, too, the court leans heavily on prior cases. The cases decided in the aftermath of Reconstruction, the period after the Civil War. The most infamous of these cases were the civil rights cases, which invalidated the Civil Rights Act of 1875 and ushered in Jim Crow-era segregation. In 1875, Congress tried to prohibit race discrimination in public accommodations. The court struck down the legislation, thereby permitting race discrimination to become pervasive and weakening Reconstruction. You might ask yourself why. The court also ends by diminishing the scope of violence against women as a national problem. It writes that Congress's findings indicate that the problem of discrimination against the victims of gender-motivated crimes does not exist in all states or even most states. By contrast, the four dissenters reject this narrow vision of the problem. The statistics Congress compiled are emblematic of a national problem, and even if the problem doesn't exist everywhere, it is of such magnitude that Congress might think that a national solution is warranted. So where does this leave us? Morrison reaffirms the notion that Congress can regulate only those non-economic activities that substantially affect interstate commerce, which could severely limit Congress's power to tackle national problems of national proportions. And it relies heavily on the idea that the court will not accept any reasoning that doesn't preserve some exclusive sphere for the states. This is an enormous blow to Congress's power to remedy discrimination and other social problems. It also reaffirms the principle of judicial supremacy, the idea that even if Congress documents that non-economic activity substantially affects interstate commerce, It is for the court and not Congress to decide what kinds of activities may be regulated. And, the court insists, it is for the court, not Congress, to decide what it means to enforce the substantive guarantees of the 14th Amendment. And remedying private societal discrimination doesn't cut it. That's an enormous power grab, too. Morrison opted to reinforce the cases striking down the Civil Rights Act of 1875, which permitted racial discrimination to become pervasive and weakened Reconstruction. Here, the court struck down VAWA and thereby permitted pervasive sex discrimination that facilitates gender-based violence. That's why the stakes of Morrison were enormous. The case deals a considerable blow to Congress's ability to tackle structural and societal discrimination.
Many, many thanks to Professor Leah Litman for contributing this case video to CRBW. Professor Litman is professor of law at the University of Michigan Law School. She is a prolific constitutional law scholar with expertise in, among other things, federal courts, habeas corpus, and reproductive rights. She is also co-founder of the important and wildly popular podcast about the Supreme Court, Strict Scrutiny. We're very lucky that she took the time to share her analysis with us.